Hi, this is Eric Allen with My Aileron, and we're talking with Jennifer McEulina, a intellectual property lawyer with McDermott, Will, and Emery. How are you doing, Jennifer?
Good. How are you?
I'm real good, thanks. What we wanted to touch on today is where should small businesses start when getting their arms around intellectual property? And really, my first question is just why is intellectual property relevant to small businesses?
Well, I think there's a lot of different aspects. First of all, there's a lot of value in intangible assets like your name, your brand, any sort of unique process you've come up with, along with sort of the obvious intellectual property aspects like a patent, an invention. And so there's a lot of value there. There's also a lot of risks that are involved in IP, and so it's important that small business owners are aware of those risks and have some sort of plan for handling intellectual property issues. For instance, one of my areas of expertise is in branding, and it's important when you come out with a new product name or the name of your company that you check and make sure that it's okay to use that name. Not only do you want to avoid any problems further on down the line, but you also want to make sure that you have all of your rights in order so that you can assert those rights against a third party later on if there is an infringement issue.
Okay, that makes sense to me, but it's such a big topic. Are there any misunderstandings on what intellectual property encompasses and how it should be managed? I mean, those are the things they are looking at, but what do you find that small businesses usually misunderstand?
Mm-hmm. Yeah, well, I think, one of the things that you had said was what does intellectual property encompass? And I think there are probably three main areas of intellectual property and then sort of a catch-all where we throw a lot of other things. First, there's patents, which are inventions. Copyright, which is works that are in a fixed form. That's where copyright protection protects written works,
Sure.
protects music, it protects art and images. And then also trademarks, which is logos, names, slogans. And then there's sort of a catch-all. There's a lot of other issues that I think we sort of categorize under intellectual property, like trade secrets. I know I deal with a lot of Internet issues that don't seem to fit me into any other thing. So I think a lot of those topics touch what small businesses are dealing with. And one of the misunderstandings, I think, is what you need a specialist for. For instance, it takes a patent attorney to prepare and draft a patent. A lot of times I see small businesses who use a corporate attorney to create their LLC or create their corporation and register that corporation's name with the Secretary of State. That's not the same as getting a trademark registration for your name or for your product. And so, that's one area in particular where I think if your name is unique and distinctive and it's valuable to your company, it's worth getting a specialist involved to talk to you about how to protect that on a national level if that's appropriate.
Okay, so within this topic, what exposure is there for employees using social networking tools and sharing data, putting things into a cloud? Does that add any complexities that a small business owner should worry about, or are they worrying too much about that?
I think it certainly depends on the business. If your business really uses a lot of confidential information, if there are a lot of trade secrets involved, customer lists, other things that you want to keep confidential, I do think it's important to be very upfront with your employees and address those issues. I've advised clients on specific clauses to put into employment agreements or, third-party contractor agreements. That's another place where this comes up a lot, to guide the employees or the contractors in what you may and may not do with company property. And I think that's a good place to put in specific clauses about what you can and cannot do on the computer that your company issues you, or what you can use your company's network for. Sure. And usually, you can cover this with a confidentiality agreement. You can cover it in the employment agreement that you have with your employees. But I would definitely be upfront with it and decide as a company, what you do want your employees to be able to do.
So it sounds like really driving it with policy, not any technology or laws, or it's really just up to almost an honor system like anything.
Mm-hmm. Yeah. One area I know that we've seen a lot of small businesses get into a little trouble, and I think your question sort of touches on this, is with unlicensed software use.
Okay.
If and that's something too where there's only so much oversight that you can have, and it really is up to the company to make sure it's very clear to their employees what you can install on a company-issued computer. We're seeing a lot of sort of disgruntled ex-employees who report on their former employers for having unlicensed software that the head of the company may or may not have even been aware of.